Robert, so I've read through it. We've now gone through it. I'm you and me to a lesser degree in our vivabarneslaw.locals.com community. It's a steaming pile of dog shit. Like I'm not trying to be. It's you read through it, and I'll say it more eloquently, like Jonathan Turley. If you redline everything that is presumptively First Amendment, you're left with what amounts to nothing more than a haiku. They keep trying to say it's not his words. He's not being prosecuted or indicted for his words. He's being indicted for his fraudulent scheme to present alternate slate of electors to the state legislators, whatever the terminology is. And I keep saying, first of all, was it Dan Goldman who put out a tweet? Fraud. I was like, they were never presenting themselves as the original slate of electors. That was never the legal theory behind this. And you claim that it's not words, but rather fraudulent schemes under a law which apparently is so vague, ambiguous, and contains this loophole that they're proposing a bipartisan bill to clarify the loopholes and the ambiguity of the 18 whatever law it is that this legal theory was based on. Robert, how do you make people who are not liars understand that A, this indictment criminalizes free speech, and even if you were of the opinion that you could criminalize speech which was putting into plan an action to defraud, the law that this is based on is known to contain an ambiguity, a loophole that Congress in a bipartisan manner right now is trying to remedy. How do you get people to understand that?
Well, I mean, I think both Turley and Dershowitz put it well in their own ways that as Turley pointed out, you'd only have haiku if you took out protected speech. And as Dershowitz put it, if this indictment was legally correct, then Jack Smith could be indicted for bringing the indictment. Because the indictment itself, there is indeed a conspiracy afoot to interfere with the people's right to vote. And it's called President Joe Biden, Attorney General Merrick Garland, Assistant Attorney General Lisa Monaco, and Special Counsel Jack Smith bringing this indictment. This indictment is the conspiracy. And it's a conspiracy that includes federal judges, including the judge presiding over the case, who's already proven her hopeless prejudice in the proceedings. So the key problem throughout the whole thing is it attempts to criminalize speech, assembly, petition, and attorney-client advocacy. Because that's the entire indictment. There's nothing in the indictment that doesn't fit one of those four actions. That everyone is either speech, assembly, petitioning the government for redress of grievances, or talking to your lawyer.
But Robert, the legal theory, which they internal email saying it's crazy. Some people didn't have as much faith in it. Set aside the fact that it occurred in Hawaii with Nixon. I don't remember the details of this. Maybe if it's worth it, you can flesh them out real quick. It's a legal theory that has been tried and implemented before, and nothing more than Trump saying, "I believe this election was questionable." They keep saying, "Oh, you filed 60 lawsuits and there's no fraud. It was, there were no Dominion voting machines." Bull crap. The suppression of the Hunter Biden laptop story in and of itself is enough to have vitiated this election from being constitutional. On its face, that's election interference. Therefore, this election, or the 2020, was the result of election interference. Floating a legal theory, consulting with counsel, solicitor-client privilege documents, which are in there, talking to the crowd to say, we're going to protest, fight like hell to save your country, but do it peacefully. We are the party of law and order. And they've criminalized all of it. Or they're attempting to.
It's all, really, the one he's really attacking is the right to petition the government for redress of grievances. And to give people some idea, this has been applied in the criminal context because in fact, from where it came from, England. So a bunch of folks were prosecuted on the grounds of seditious libel for the way in which they filed a petition with the government. And the right to petition was already recognized. It goes back to the Magna Carta. And the English courts recognized in the 1600s that no, you cannot criminally punish anything that involves petitioning the government. This is why in certain contexts, whistleblowers are protected. Others, for example, let's say you call the other context in which this has already been litigated in America is people making police reports. That you can't prosecute people for police reports unless they specifically lie in a specific way to the police officer. Outside of that instance, you can't sue them generally. Why? It's petitioning for redress of grievances. And because in what Jack Smith's theory is that the only permitted petition for redress of grievances is to go to the courts, number one, and number two, to only go to the courts on theories he agrees with. If it's not both, it's a crime now. That's how insane this prosecution is. So people like Michael Tracy, other Glenn Greenwald, other people on the left are like, this is the most dangerous indictment to core constitutional rights in the history of America. It just is. It just goes way past Donald Trump.
I just lost my thought. It had to do with, oh, son of a bee sting.
And people forget, right to petition for redress of grievances was considered more fundamental than any other right at the time of the American Constitution. Because what it was is they would keep petitioning the king and the parliament, and king and parliament kept answering it with injury as the Declaration of Independent States. And so the right to petition for redress of grievances, even though Amy Coney Barrett forgot it existed, is a critical, essential, and foundational right under the First Amendment. And what they're saying is, hey, Donald Trump, you can't petition the vice president for redress of grievances. You can't petition Congress for redress of grievances. You can't petition a governor or state legislature or state official for redress of grievances. That's all criminal. The only thing you can do is go to court. Well, that would effectively strip and deny all of the rights that are in the petition for right to redress of grievances. It would also, he actually does implicitly attack the judicial filings too, which is also part, by the way, of petition for right to redress of grievances. It's why inmates have a right to bring habeas petitions while they're pro se inside, or other petitions. Like my favorite one ever brought was a petition for specific relief, in which the inmate asked that the 8 people who screwed him over, the judge order them to kiss his ass. It was, a very unique petition. But this is where this is a direct attack on the right to petition your government for redress of grievances. If the president can't do it, you sure can't without going to prison.
Now, this is the thought that I forgot. You'll tell me if I'm wrong and if I'm strawmanning it. They focus a lot on the fraudulent scheme, which was to submit fraudulent electors. They keep saying fraudulent electors, as opposed to...
That's part of petitioning for redress of grievances. That's what that is.
Well, but they keep using the word fraudulent electors to like persuade the public that they were there saying, we're the electors, here's our documents, where they're not using the term alternate electors. And as far as I understood of the legal theory, the scheme, even if you want to call it that, these electors were not being duped into thinking they were the original electors. They were going to present themselves as saying, we are the alternate slate of electors that should be recognized because the original slate of electors are the result of a fraudulent, vitiated, unconstitutional election, and they should be disregarded. In which case, nobody's going in there fraudulently trying to convey that someone is what they are not. They are saying exactly what they are, alternate, and that the original should be disregarded because it was the result of vitiated consent, whatever. Am I wrong on that, or
it's garbage constitutionally, even if the factual allegations were true? Now, the second problem is it's putting a label on conduct that's just not accurate. So that the saying I want alternate electors considered is petition for redress of grievances. It can't be fraud. Otherwise, you can label disagreement fraud. And that's what Turley and others were like, whoa, this indictment goes way past the pale. These are legal professors that aren't Trumpers and that haven't been that aggressive defending Trump and the other charges. These cases where they're like, well, this case goes way past anything reasonable. This is a pure attempt to criminalize First Amendment activity and to use Trump to establish the precedent to do it to anyone else. If you make any speech that could impact government agency that the government later determines they don't think was accurate, now you go to prison. That would gut all First Amendment protection. Gut it. Eviscerate. If this indictment is allowed to go forward, the First Amendment is dead in America. Period. Dead. Now, that's how big this case is.
Trump was taking some mockery on the internet because he said the Supreme Court must intercede because this is election interference. I thought people were making fun of him because they didn't understand what the word intercede meant. And I still think that that's the case, because I think people thought he meant to say intervene, and people didn't actually realize what intercede means at a legal level. When you like, what has to happen for a court? Could a court, on its own volition, say we are dismissing this indictment, even though it was ratified by a jury of his a group of his peers in D.C.? Can a court say this is outrageous, and we're ending it of our own volition?
There's procedural mechanisms. So what you need is an appealable issue. Now they're going to have an appealable issue out of the gate, because the judge, who everything about her screamed prejudice, and just being an Obama appointee is considered insufficient prejudice in our system. I don't have a problem with that. The issue was as her actual statements in other cases that showed a bias against Trump that went way past what the judge said about Disney. That was the grounds for DeSantis's motion to disqualify in the Florida proceeding. But it's not only that. Her personal history is she has involvement with people who will be witnesses on some of the grounds of motions to dismiss, because she was a lawyer at the law firm with Hunter Biden involved in the Burisma corruption scam. And one of the motions to dismiss that will likely be brought is that this is a selective prosecution as punishment for Trump's speech concerning Biden family corruption, that will be part of it. How can she be the judge over something that she was involved in? So that's the extraordinary uniqueness. But any doubt anybody had about how prejudiced she would be was answered very quickly, because the government came in and demanded what they call a protective order. It's really a disguised gag order.
Mm-hmm.
And it's a gag order meant to prohibit the American people from knowing information that makes the prosecution's case look bad in this politically charged case. And what she did is she ordered the defense to respond in less than one business day. Utterly ludicrous, utterly preposterous. She's so prejudiced, so corrupt. She is incapable of being an impartial jurist. So what Trump announced and his legal team announced is they're going to seek motions to disqualify her. They only have some facts. They don't know all the facts that may be pertinent to a motion to disqualify. And they're going to be a motion to transfer venue, because the chief judge, and other judges in D.C. came in and watched gleefully Trump get arrested. No one has ever heard of this ever happening in the history of federal courts. These are judges, Amy Berman Jackson, corrupt hack judge who should be impeached. The chief judge of the District of Columbia should be impeached. This judge assigned to this case should be impeached. And it's where the House should start talking about it now, because this is way, way, way out of control. The federal D.C. judges can't wait to weaponize and abuse and misuse their power in a conspiracy to deny the American people their right to vote. These judges themselves, under the Jack Smith legal theory, are the ones who should be facing criminal prosecution and punishment. That is how egregious this is, because it's not only egregious in how it would eviscerate the First Amendment in America if this case allowed to proceed, but it would also greenlight the most corrupt judicial system in America, misusing and abusing their power in the most nefarious and obvious and evident manner. So they'll bring the motion to transfer venue as well. Now, I'm sure this corrupt hack of a judge will deny all of these motions and reliefs and grant the ridiculousness of the protective order. However, contrary to what Turley was saying and Littman and other people that thought this is somehow a mistake, you need to put all of this on the record right away. When you have a politically corrupt judge, you just got to call it out. If you don't, they will railroad you and crush you. And yeah, they'll take pot shots at you as counsel, and they're going to do all that garbage. You can't worry about that. You got to go right at it, right out of the gate. You got to deal with it up front. I mean, to be honest, Roger Stone's lawyers screwed up by not making it a major issue from day one. It was clear Amy Berman Jackson was a political hack who would whore her power for partisan purposes. She proved it in the trial. They should have gone after her right away because they had grounds to do so. There's even more grounds with this judge. But get all of those on the record, because every single order she makes is appealable. So you'll give the Supreme Court every possible chance to intercede and intervene by simply taking up one of these petitions. Now, a smart media company out there, whether it's Jim Hoft or Julie Kelly or Mike Cernovich or anybody else, has under the D.C. court rules a right to bring their own third-party proceeding in the case. Because of the protective order, that has been considered to be a violation. It's a prior restraint on speech. And if you have a lawyer willing to disclose information about it, or a party willing to disclose information, it's a violation of the First Amendment free press rights of the Julie Kellys and Mike Cernoviches and Jim Hoffs and Gateway Pundits and Alex Joneses and all the rest of the world. They have an independent right to challenge this. And a bunch of media people, if they're smart, will in fact do so. Say, you have no business. This is the most political case in American history. You have no business suppressing and censoring information about this case. None. It's not your constitutional privilege. We get you're a political hack. We get you're involved in the corruption of the Biden administration, previous to the Biden administration, with Hunter Biden specifically, and your prior legal practice. But that's no grounds to be doing this nonsense. So expose it for the joke of a proceeding that it is. Continue to go that route. Pursue every remedy that gives you a procedural means to get up to the Court of Appeals and the Supreme Court. The protective order, you can appeal. The denial of motion to disqualify, you can appeal. Denial of motion to transfer venue, you can appeal. Now, after that, you likely bring motions for pretrial discovery, subpoenas. Get the judge to basically show that she won't provide you a fair trial. Get it, prove it, make her be done. By the way, when you have a real dumb judge like this one is, politically prejudiced, who can't hide her prejudice. Like, if you're this prejudiced and the defense lawyer asks for 3 extra days, you give the defense lawyer 3 extra days so you don't look like you're an obvious bigot. She should be sent back to Jamaica. We should deport her back to where she came from. Maybe we should have natural birth citizenship as a requirement for federal judges in this country, if she's any proof of it. But we've had enough foreigners running the country at this point. We got a guy who's been a foreign agent his whole life as the president. Before that, well, you can answer your own question. A couple of back in 2012, who appointed this judge. But if you look at the fundamental, file motion after motion after motion, file motion for pretrial right to discovery of a bunch of information, because they have made it issue in this case whether or not the signatures matched in Georgia and whether or not Trump knew that they did, according to the government. They didn't, by the way. I know because I was down there. Well, that's grounds to get them all. Well, Judge, we need to subpoena all the ballots. We need to subpoena all the ballot signatures. We need to have all of it because we're going to prove that, in fact, as a matter of objective truth, the signatures didn't match. And the statement that they didn't match was not only subjectively believed to be true, but also objectively true as a matter of fact. And the same with every other challenge. Wisconsin indefinitely confined. The Wisconsin Supreme Court acknowledged that, in fact, they shouldn't have been voting. How many were there? Ballot signature matches in Arizona. Ballot signature matches in Pennsylvania. All these places where it wasn't done. Let's take a look at it. We need it. Force her to say, I deny you. How dare you? I mean, she can't wait to lecture Trump. She can't wait to wield that gavel to hurt Trump and to gut American constitutional democracy. This is why we shouldn't have Jamaicans on the bench to begin with. Go back to Jamaica. This is America, not British territory. But that's the dynamic of who she is and what she's about, and that whole court system in D.C. is about. So put her to the test when they're as dumb and as arrogant as her. Sucker her to make mistake after mistake after mistake after mistake. Make it as egregious can be. Put in proffer after proffer, offer of proof after offer of proof. I've had the distinct privilege, if you call it that, to deal with a lot of corrupt, dumb, hack judges, and have won a lot more often than I was supposed to because I understood how to work those judges. You use their stupidity and prejudice against them.
Robert, explain to the world who may not know how preposterous or outlandish it is that who were the 2 judges that were sitting in the courtroom as Trump was brought in?
One of them was Amy Berman Jackson. There were 3. Another one was the chief judge. The same
Just
chief judge that was complicit. To give you an idea, by the way, they should
why
also.
are they there? But why would they be there?
None. No one has ever heard of this. Ever heard of this in the entire criminal defense world. No one has ever heard of it.
Judges sitting in there, jury. This is called the arraignment, or
the arraignment. They were there to say, "Look at Trump getting arrested. Look at it." They were gleefully there. They have no business on the federal bench. And if any Republicans had any either brains or balls in Congress, then they would be bringing up impeachment on those judges right away. I mean, this is going to get out of hand fast unless lots of people step in and do something about it. This is going to get way out of control. And the answer is not to be Steve Dace and hide under your desk and say, let's give up to the corruption. Not to be Kurt Schlichter and hide under your desk like a coward, or Jesse Kelly and hide under your desk like a coward.
Scaramucci. What's the name?
Scaramucci. And cower to and give in and reward this corruption. This is the time to fight back by every legal means available. So the other thing is you then bring motions to dismiss. Every denial of a motion to dismiss is also appealable. You request evidentiary hearings and you document what you would have proven if you were given them. This judge will be dumb and arrogant enough to deny you those evidentiary hearings, to deny you that discovery. Every single one of those rulings also appealable. So you get the judge to give appealable rulings. You try to get her to do it as dumb as possible. And so you have the best grounds. And that's how the Supreme Court can step in before it gets way even further, completely irreducibly out of hand. Now, let me give some of the grounds that you could dismiss here. Motion to dismiss for violation of First Amendment free speech rights. Motion to dismiss for violation of right to assembly. Motion to dismiss for violation of the right to petition the government. Motion to dismiss for selective prosecution based on disparate treatment between you and similarly situated individuals. Heck, you can just point out Trump versus Biden. You don't have to go much further than that, but there's plenty of other illustrations and examples, such as Trump now versus 2016, when Hillary Clinton and every other Democrat was running around begging, spending millions of dollars in advertising, telling electors to violate their oath and elect Hillary Clinton rather than Donald Trump.
But you could disparate also. Trump was acquitted on this from the impeachment. I mean, this overlaps.
Well, I'm going to get to that. So then you have a motion dismissed on selective prosecution because it's political retaliation because he's the leading political opponent of the country. Then you have a motion to dismiss on selective prosecution grounds because it's retaliation for him exposing Biden family political corruption. Then you have a motion to dismiss on 4th, 5th, and 6th Amendment grounds, as well as common law grounds, because the entire case is built on the breach of attorney-client privilege approved by that chief judge political hack who was sitting there gleeful that Trump was indicted. He was the one who showed up in the courtroom, was key to all of this illicit breach of attorney-client privilege. Attorney-client privilege implicates First Amendment, 4th Amendment, 5th Amendment, and 6th Amendment rights. Those are grounds to dismiss. Then that doesn't stop. Because then you get to the impeachment clause question, which apparently a lot of these so-called, the legal left these days is really pitiful. And much of the left is in general. I mean, this used to be Robert Kennedy types, people with robust intellects, people with quick repartees. Instead, they're arrogantly incompetent. They brag about how stupid they are. So they had these people saying, double jeopardy, I can't apply. Impeachment's a civil proceeding. You must never have done criminal law. No, you must have never read the Constitution. You must have never read the legal scholars that have been discussing this for the better part of a century.
So when explain what it means when jeopardy attaches, because someone had asked this in a stream, I think last week, and I was like, it sounds like there's overlapping jeopardy issues, even though under the impeachment, it wasn't imprisonment, it was removal from office. So what does the exposure to jeopardy mean as to how it could also not apply now? Because he has been literally, what was the word? He was impeached, but acquitted on the very same basis. So what could apply by way of double jeopardy?
Sure, I'll cite, there was two different Justice Department memorandums, one in 1973, one in 2000 on this precise question. And I'll quote from it, but I'll quote from it, quoting from the Constitution. Judgment in cases of impeachment shall not extend further than to removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States. But the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law.
Interesting.
So
Okay.
how is it, why didn't it say the party, whether convicted or acquitted, is subject to these provisions? It said, no. It said only if you're convicted can you be liable and subject to indictment, trial, judgment, and punishment. Now, my view is that is so extensive that you can't indict a president or former president, period, without first securing conviction in the Senate, for which there's very good constitutional reasons to put that barrier there. But because otherwise the president is subject to the whim of any local prosecutor anywhere in America. And that would completely eviscerate the entire constitutional framework. But putting that aside, it definitely applies here, because here he's being indicted for the exact same conduct he was acquitted of. And in fact, to go further later on, as the memo puts it,
but hold
this
on.
argument is, quote, an argument of strong force and has some obvious appeal. That was what the Justice Department admitted. Many legal scholars have agreed.
And the idea there being, the jeopardy is if convicted, then you can be indicted. And so the jeopardy attaches when he's impeached, because if he gets convicted if he gets impeached and then convicted, then there's jeopardy of subsequent indictments on that basis. If he gets acquitted, well, he's gotten past the exposure, and you can't then re-indict him where that jeopardy had already attached and been, I guess, eliminated because of the acquittal.
Completely. And they go through that this fits statutory construction, constitutional construction, historical construction. The DOJ tried to weasel their way out of it and say maybe they could prosecute him anyway, but they didn't have to address the issue because it was avoidable at the time. So you have those issues. Then you have three other motions to dismiss. One is that the special counsel is a unconstitutional position, and he's also been an excess of power in this case. How do we have the so-called independent counsel that's free of the Justice Department? No, we don't have a system for that. The president has all power, and they're trying to say, "Oh, Biden had nothing to do with it. This guy's totally independent." Well, then he doesn't have any constitutional power, period, because his only power can come from the president. And if he's totally independent of Joe Biden, then the indictment has to be dismissed because he has no constitutional power to seek it in the first place. Then you have additional motions to dismiss because of four other grounds, actually. One is misconduct in the selection of venue. And that is that they deliberately they could have chosen multiple venues. Trump was in different places. The lawyers were in different places where there's conduct alleged in the indictment. They could have brought the indictment in Florida, New York, Virginia, West Virginia, a whole bunch of California, a whole bunch of places. Why did they choose the District of Columbia? Was it because they could go judge shopping? Was it so they could go jury shopping? Selection of venue by a corrupt prosecutor is itself a constitutional violation in these instances. On top of that, I think that the mere fact that he cannot get an impartial jury pool and he cannot get an impartial judge in the District of Columbia, given the chief judge's bias and prejudice in the case, then I think you have grounds on due process. For due process reasons, you're entitled to an impartial judiciary. For due process reasons, you're entitled to an impartial jury, as well as the Seventh Amendment of the United States Constitution. I would bring motions to dismiss on both grounds. And then a motion to dismiss on general government misconduct on the way in which they conducted this proceeding, violating attorney-client privilege, threatening lawyers to force them to try to flip witnesses, and other comparable illicit behaviors. Then you have the procedural motions that I mentioned. The protective order is garbage. Any judge who signs off on it is a political hack who should never be a judge again in America. And media should intervene to object to that gag order. The motions we discussed, transfer of venue and disqualification, discovery, pretrial subpoenas. Also, he should bring a motion to stay the proceedings at some point. Mm-hmm. Say, let's stay this until the election, because otherwise this trial will inevitably interfere in an election. And it will do what supposedly the indictment's there to prevent. The indictment's there to stop any interference with people's voting. How does indicting the leading opponent not interfere with people's ability to vote for who they want?
Robert, no one's above the law. Robert, come on. If he broke the law, he's got to be indicted and convicted before the election.
Then wait till after the election, right? If you're not there to interfere with the election, you're only there to make sure he's held responsible to the law. Then wait until after the election for the proceedings. Real easy to do. And when they don't do it, it shows they want to do what they're accusing Trump of, which is conspire to interfere with the election. And if Jack Smith's theory is okay, all the federal judges could be locked up and sent to prison tomorrow. They have not thought this through at all, because the Trump haters are so power hungry. They don't think past the short-term power. They're like dumb criminals that end up in prison. Like people say criminals have low IQ, and I say, no, caught criminals have low IQ. Now, he has also robust trial defenses. The trial defenses include that, first of all, the statements he made are objectively true. The 2020 election, an honest constitutional 2020 election, elected Donald John Trump, not Joe Biden, his fraudulency the second. That's objective fact. That's part one. And he can document all the proof of his specific allegations concerning it. I mean, they were dumb enough, arrogant enough to think to mention Georgia's signatures. You don't mention the one thing that is your most egregious vulnerability. These dimwits don't know that I was on the front grounds and they were terrified to let us match the signatures. They never let us match the signatures. And the reason they didn't is and by the way, they never try to ask me to testify for reasons that are blatantly obvious, the government. These people saying, oh, Trump's law, Pedro Gonzalez, that Jew-hating grifter hack who went from Bernie to Trump to now being an anti-Trumper, was like his lawyers didn't believe in this case. Yeah, we did. And I still do, because I'm right. That's why. And Jack Smith is full of shit. So the reality is that the election was stolen, old-fashioned stolen. It was done constitutionally unqualified people voted. Constitutionally unqualified ballots were counted, and they were counted and canvassed in an unconstitutional manner that directly violated the Constitution of the United States. A constitutional conforming election undoubtedly, indisputably elected Donald John Trump president of the United States. And any claim otherwise is hogwash. And if they believe their claims, why were they so scared and terrified to even publish the ballots they promised to publish, to let us look at any signatures in any significant scale in any contested state? They know they stole it just like we did. Now, the second line of defense is he subjectively believed it. And that goes to what's called good faith. Now, you have, Katyal and Barb McQuaid and these corrupt hack former prosecutors who never should have been prosecutors. They're exposing themselves now as people who never should have been prosecutors. So-called law professors who make a joke out of the practice and profession of law, saying that Trump's subjective belief about the election is irrelevant. Obviously, they don't even understand the indictment that they're cheering on and that they helped orchestrate. There is no fraud if Trump believed he won. The entire fraud is that Trump knew he didn't win and was so using deceptive means to trick other people into saying he did. That's the entire indictment. If he believed he won, there is no fraud as a matter of law. There is no interference with the right to vote if you're trying to make sure the vote is accurately counted. It's preposterous to claim otherwise. So his subjective belief is relevant, and in good faith, this goes to willfulness and conspiracy to defraud in general. I've litigated these cases for going on a quarter century. You get to include everything you relied upon, everybody you talk to, including your legal advice. And the idea of criminalizing legal advice is an even more insane notion in this case. I mean, it's about constitutional law professor Jonathan Eastman, but people like me he relied on, and I'd have no problem attesting in this case. Now, they're not going to let me near anywhere or anything, but for that precise reason. But if you look at this, he had plenty of sources to rely upon that were reliable, dependable, believable, and credible. They try to highlight the few people who disagreed with him on a few scattering set of items.
Yeah, and the one or two messages or DMs or text messages where they use crazy theory and whatever. Who knows how they even meant those words?
Yeah, I mean, and that doesn't even matter. I mean, a lot of theories you consider crazy, but you consider may work, legally correct. And to give an example, the Democrats themselves put out their own memorandum where they game planned these exact kind of challenges that Trump brought. Number one. Number two, law professors wrote heavily published, in the Trump hating law professors, by the way, pieces on how these exact challenges could be brought. That's how absurd it is to make the claims that they're making in this proceeding. But so a jury would have to conclude there was no objective basis whatsoever for Trump to believe what he did, and by beyond a reasonable doubt, and believe that he never believed a single statement he ever made, and that he always believed Joe Biden won the election beyond a reasonable doubt. There's nobody in America who believes that. So that's why they depend on liberal political hacks in the DC judicial system and jury to secure a bogus conviction. And these lunatics are so out of touch with America, so much in a parasitic capital, that, they let them eat cake Marie Antoinette look like a well-connected genius by comparison and by contrast. They really believe that if they can rush a trial, railroad Trump, and convict him, that will prevent Trump from being elected president. It can't constitutionally or legally, but they think that his voters will all abandon him. And that's where this case has a comparable analogy, and it's the Alex Jones cases. They want to Alex Jones, Donald Trump. They want to remember what a complete joke and embarrassment those Connecticut and Austin, Texas trials were. I mean, you saw those. I mean, almost everybody who saw them said, it's worse than I even predicted it would be.
It was worse than anyone predicted, and it wasn't even supposed to be on the merits. And nonetheless, even on the damages, it was worse than anyone could have possibly imagined.
Completely. They think they can get away with doing the same thing to Donald Trump.
Yeah.
And that's what they don't understand is within their little courthouse, they can. But they're depending on the court of public opinion abandoning Trump. Because sooner or later, especially if he wins in 2024, imagine if they try to lock him up. Do you know what that would do to his elect? Do you know how intense his supporters would go to the polls? Do you know how much they would organize? Do you know how much it would be the biggest turnout in American history? And what message would it send to the D.C. courts that the guy they just locked up is who America said they want as president of the United States? It means those judges need to be going to prison next. That's what it means from the American people. So, but they're that dumb. They're that arrogant. So establish the base, educate the court of public opinion, expose it for the joke of a proceeding it is. And hopefully, after all of this is said and done, when Donald John Trump is president of the United States in 2025, we start to meaningfully reform our criminal justice system. Get rid of D.C. It shouldn't exist as a political jurisdiction. Our founders had no intention that the swamp would get to govern the swamp, that the swamp would get to govern the critics of the swamp. They've shown through all their history, but most egregiously in the last half decade, with January 6th cases and Trump cases especially, they cannot be impartial. They are not capable of being impartial. There needs to be no state court system in D.C., no federal court system in D.C. No, just get rid of it. Congress has the right by legislative fiat to get rid of them tomorrow. And if they had any cojones, they should. And hopefully in 2025, they will. Second remedy, we need to put into statute, because our Supreme Court has forgot it was meant to be there in the Constitution, that you have a right in any and every criminal case to transfer it to the venue of your home residence. This letting them abuse venue like they've been doing for a long time. I brought this up almost 15 years ago in the Wesley Snipes case, more than 15 years ago now, where they prosecuted him in a place he'd never even been. Why? Because it was the per capita capital of racial hatred incidents in the past decade, according to other organizations other than myself. They did White Nationalist Father's Day. It was Ku Klux Klan Central down there. They invited Snipes to go out to see the tall trees out there. That they still had statues to the founder of the Ku Klux Klan and the head of in front of the courthouse. Now they were so stupid they misspelled his name because they thought his name was Forrest, like a regular Forrest, and didn't realize there were two R's there. And then they tried to hide it after I exposed it underneath some bushes behind the thing. We found it anyway. But, it's long overdue. We make sure that right is present. That's a right Congress can make sure of and guarantee. And third, Start limiting all these stupid federal criminal laws. We need to get rid of the FBI. We need to get rid of the CIA. We need to get rid of a lot of these places. Return law enforcement back to local and state government. The federal government has proven they're incapable of impartiality in this context. No more, make federal power really limited, and get rid of about 95% of the federal criminal statutes you have on the books.
Robert, I think this might be the pin in it. Let me bring up Adam Schiff's tweet. He puts out this tweet, which says, transparency will be crucial in the trials of the U.S. versus Donald J. Trump. It's why dozens of my colleagues join me today in urging that these proceedings be broadcast for the public. If the American people are to accept the outcome, it will be vitally important for them to witness as directly as possible the full facts and the evidence. Now,
and that means, by the way, they've been secretly conspiring. I think two other challenges should be brought. I have reason to believe that this judge was not randomly selected, but was handpicked by someone associated with the chief judge to make sure it went to her. And so I think that that should be investigated. The federal courts get away with this quite a bit. They claim, oh, this is random assignment. There's always somebody behind the scenes. And I've heard from people connected to those people behind the scenes that routinely happens where here's how they do it. They randomly select. They don't like the judge. They do a random selection a second time. Then they do it a third time. Forensically review how that was done. Forensically review how the grand jury was selected. See if what bias and prejudice or lack thereof in the clearing thereof in the grand jury process was done. That is often in violation of the protocols and procedures. See if it wouldn't surprise me if they deliberately excluded a disproportionate number of black people from this grand jury because they wouldn't trust black grand jurors to indict Trump like they would white Democrats in D.C. To indict Trump. And they should go after both of those procedures. But the Adam Schiff saying this is a sign there's been, in my view, talk beforehand. Because they wouldn't say that if they thought this judge was going to give a full trial where Trump was able to present all his defenses. They're saying that means they already know this judge will railroad Trump and deny him the opportunity. And so what they want is a Stasi Soviet-style show trial that looks like Alex Jones, where all of the bad evidence comes in, all adverse evidence comes in, but none of the exculpatory evidence is allowed in. None of the good evidence is allowed in.
And that was my question. If they say, make the trial public, after we've gagged Trump, after we've limited, excluded evidence, after we've, curated the evidence that we're going to allow to be presented at the trial, then we have the public trial, and it brought back.
These people are dumb enough to think this works. Look at what happened with Alex Jones. The entire objective with Alex Jones was two things. One, they misread the man. They thought they had this caricature of him shown in the show Homeland, which is they thought he was solely about money. He didn't really believe in any of it. He was doing it for money. So once his money was threatened, he would forfeit and go home. Not realizing he really doesn't care about the money. He likes using the money as a tool of power to get the message out. But otherwise, that's not who Alex Jones ever was. And you could know that by the fact he stuck with 9/11 when he was forfeiting the opportunity to be the second Rush Limbaugh by doing so. So, I mean, he made his whole life history told you that. But the other aspect was they thought we're going to so shame Alex Jones and his audience that they'll abandon him. They won't watch InfoWars. They won't support it. They won't go to InfoWars store. In fact, the Connecticut, brother, nobody has to doubt this. Connecticut lawyer came out and said it right afterwards. Little side point for those people that might have watched George Gammon's excellent video on how he decided to get involved in public life. He talks about the corrupt attorney general of Connecticut who politically harassed him that put him in such a depressive state. And that was Tricky Dicky Blumenthal. Well, Tricky Dicky Blumenthal was one of the key orchestrators and his family behind the attacks on Alex Jones, by the way. But the Connecticut lawyer came out and said, our goal is you out there that ever listen or watch Alex Jones, quit supporting him. That's what you need to do. As long as you quit supporting him, we have achieved our victory. And what's happened, according to bankruptcy filings, people's support went up. Didn't go down. It went up. They're going to keep InfoWars on the air no matter what. And they're going to keep Alex Jones on the air no matter what. And the other irony of this, Alex Jones had been thinking about retiring after 2016. He's like, yeah, I've achieved a lot. Man, I've been through a lot. But them going after him, that guaranteed he stayed in the fight. So they don't understand Trump. They don't. Whatever you think about Trump, one of his greatest traits is he's got a spine of Pennsylvania steel, and cojones the size of 6 continents. So he ain't going nowhere. And they don't understand the American people, that the tolerance for this is over. They're going to get an election day verdict that's like Patrick Henry's verdict, all the way back, that helped ignite the American Revolution in the first place. And we probably need a second one in order to straighten out this corrupt professional class, particularly in the D.C. judiciary, but elsewhere, that is trying to destroy the country.
Well, from your mouth to God's ears, Robert. And there is the discretion of a federal judge to say we will broadcast this trial live.
No.
So it's an empty.
I think only the Supreme Court can approve that. The entire federal court system is prohibited from video broadcasting any proceeding at all. Outside of, you can do it within a courtroom. So remember, Ghislaine Maxwell's case, Good Logic went down.
Yep, and they had it broadcast to another room.
When there's a carryover, a spillover, they can broadcast to another room inside the courthouse, but it's only considered an extension of that office.
So so the scumbag Schiff is making an offer, pretending to be on the side of transparency and justice, knowing damn well that it can't even happen in reality.
Yeah.
Okay.
That's the goal. But I mean, Trump's lawyer did pretty decent today. Make it the media rounds, saying they would welcome, of course, public trial entirely. And he said, given what Mike Pence said, this was a smart presentation. There's a little bit of a preview to Pence, he said, just by what Pence said in his book, if unless he's going to say he lied in his book, Pence is going to be a very good witness for us. So it was a smart move to remind Pence to, mind his Q's and T's. But they try to use protective orders on discovery, and they try to use bail as means to not only censor speech, and press access to criminal proceedings, but also to gut your ability to defend yourself.
Mm-hmm.
So years ago, I sued the lead government witness in the case for my client. The government went absolutely berserk. They said, that's obstruction of justice and witness intimidation and blah, 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 blah. I was like, no, it isn't. It's called legal advocacy. The fact that you have a witness who's a complete, utter fraudster is your problem. It's not my problem. My duty is to sue the SOB. And they backed off once I went through all of the rights. And in fact, this has been litigated. And when it's been litigated, the courts ultimately back down and recognize they have no business interfering with the ability to defend yourself, which must include access to public discussion about witnesses in court proceedings. So we'll see how that unfolds. But they may be about to put on the worst show trial in the history of America. Hopefully there's enough. The Supreme Court's watching. The American people are watching. And Election Day is probably the best way to reverse the insanity of whatever takes place in that case.
I was kind of hoping they would broadcast the trial, because if they thought a lot of people were watching Rittenhouse and Johnny Depp, my goodness. Yeah, and people would watch and they would understand like they did when they were watching Alex Jones.